The people in this country who have been trying to run away from the Madlanga Commission by pretending to be sick are being exposed one after another. Suliman Carrim, IDAC head Andrea Johnson, and General Khan all claimed they were too ill to appear before the commission and instead went into hiding. When Suliman Carrim's lawyers came before the commission to defend him, claiming he was too sick to attend, Advocate Chaskelson completely turned the tables. After listening to their arguments, he played a video clip allegedly showing the same Suliman Carrim, who was said to be hospitalized, out shopping instead. That shocking moment left the entire hearing stunned. It is clear that the fear of Lieutenant Mkhwanazi and the Madlanga Commission is making some people do everything they can to avoid answering questions. If you're a true supporter of Lieutenant Mkhwanazi and you're happy with the work the commissioners are doing, hit the like button, comment, Viva Mkhwanazi, and don't forget to subscribe for more updates. Jabulani, roll the video showing how Carrim's lawyers tried to defend him, only for Advocate Chaskelson to shut down their arguments in less than 10 minutes.
And having to rely on the medical practitioner and the family, and so there might be practically some delays in obtaining the level of specific instructions that we have to now obtain. But as I say, I'm in your hands on that. You will direct as you need to direct. The second point, and I think my learned friend and I have reached an in-principle agreement on this, but if I'm wrong, no doubt he'll correct me in reply, is that Friday, insofar as, I'm just using Friday as the placeholder date, Friday, insofar as we end up needing to discuss medical conditions, hospitalization dates, even identity of the medical practitioner and the speciality that they may or may not specialize in, obviously impinges potentially on my client's medical privacy rights, and also around causing unnecessary public, in an open sense, public speculation about his state of being or not being. And I've already flagged with my learned friend that we might need to be because for the exact reason that I can't read to you what the contents of the medical report actually says, I have to use all these sideways descriptions of directing your attention to content. It might be appropriate for us to have that debate, at least in camera, without the journalists and the outside world reading in, to the extent that we need to go into that medical history and the details. So never mind the timetable issue, Chair. I think in addition to, if you direct that we have to bring the formal postponement application in the way that it's posited, I'm giving advance notice to you as the Chair and the Commissioners, and I've flagged it and I've discussed it with my learned friend, and he was very understanding, I'm grateful, that we might need to then have that as an in-camera session so that my client's medical privacy rights are protected and his dignity is not unduly impaired as a result of what information we, as the Commissioners, the evidence leaders and his legal representatives, need to have a frank debate about in a way that still manages to protect him. So, Chair, those are, may I just check with Ms. Matlingwane, who usually holds the purse strings?
Yes.
Ms. Matlingwane says I've done my job, so it's fine. Thank you, Chair.
Thank you. Mr. Chaskelson, any reply?
Brief reply, Commissioners. Chair and Commissioners, you'll recall that 3 weeks ago Mr. Carrim was postponed to today's date. He's not here today, and we received a doctor's note yesterday that refers to his admission to hospital on the 17th of June, which is more than a month ago. When we received that doctor's note yesterday, it seemed to explain Mr. Carrim's apparent inability to appear today, but it didn't explain his inability to answer, at least in part, the Regulation 10.6 notices that had been served on him and that I addressed in the Commission 3 weeks ago. You'll recall, Commissioners, that we're still waiting for Mr. Carrim to tell us, for example, who the auditors of his companies are. There's nothing in his doctor's note that suggests that his health conditions are of such an order that he's been unable to do that for 2 months. Similarly, we're still waiting for Mr. Carrim to furnish audited or even unaudited financial statements for 3 of his companies, Ziggy, Tasmika, and Tamiz. There's nothing in the doctor's note that suggests he'd have been unable to issue a simple instruction to the officers of his companies to do this. And I want to emphasize here, we're talking about a group of companies, including Ziggy, Tasmika, and Tamiz, that have been paid hundreds of millions of rands from the Northwest Provincial Government and Northwest municipalities in the region of which he's the ANC Treasurer. Companies in this group continue to perform services for those organs of state and continue to be paid millions of rands by those organs of state. We're talking about multi-million rand businesses, not, family-run sort of small businesses that have to shut down if their owner is unwell. So if Mr. Carrim took the trouble to ask someone, he ought to have been able to arrange that we receive the financials we've been asking for months now. That's where things stood yesterday. Mr. Carrim seemed to have an excuse for not appearing, but he did not seem to have any excuse for failing to answer any of the questions in the Regulation 10.6 notice we sent him 2 months ago, and for not providing any of the documents we sought in that notice, almost all of which he had undertaken to provide when he testified when he was healthy back in, I think it was April. That was yesterday. And then after we received the doctor's note under cover of a letter from his attorneys yesterday, late in the afternoon yesterday, we received 2 different whistleblower reports, both confirming that Mr. Carrim and an entourage had been seen yesterday going out for lunch at a shopping centre in the Western Cape. The 2 reports corroborated the same details. They seem to be independent of one another, and they've now been confirmed by eyewitnesses at that shopping centre, who we have independently contacted. So we now have it from multiple different sources that someone who seemed very much to be Mr. Carrim arrived at the shopping centre with an entourage, went into Woolworths before going off to have a late lunch at a restaurant in the shopping centre. We've subpoenaed CCTV footage from the shopping centre, and we expect to have it received, and we expect to have it thoroughly analysed by midday tomorrow. For now, we have a concern that Mr. Carrim may be taking liberties with this commission. And that concern is amplified by other whistleblower reports that we've received indicating that Mr. Carrim has been seen at social gatherings in the Northwest over his period of ostensible incapacity. So we are going to issue a subpoena later today to the hospitals at which he's been receiving treatment to establish when he was admitted and when he was discharged, since he testified at the commission. We're also going to be issuing a subpoena to his doctor, who's based in Cape Town, to establish the dates on which he has seen Mr. Carrim. And we don't expect that it will take us more than a day to obtain this information. And what we would like is for the matter of Mr. Carrim's appearance or non-appearance to be stood down until Friday morning, or maybe Friday lunchtime, when it can be considered on the basis of a formal postponement application, which we would ask this commission to order him to bring by 10 o'clock tomorrow. The evidence leaders will reply to that postponement application by 6 p.m. tomorrow, and it could be heard by Friday morning at 9:30. If Mr. Carrim's legal team needs more time, if we can have that postponement application by 5 p.m. tomorrow, we would undertake to respond to it by 10 on Friday, and it could be heard on Friday afternoon, not Friday morning. But what we do expect the postponement application to address is at least the following issues. The dates on which Mr. Carrim has been admitted to hospital over the last 4 months, the dates on which he's attended medical consultations over the last 4 months, his travel movements over that period, whether he's attended social engagements over that period, and whether he's played any role in the management of his businesses over that period, and if not, who's been responsible for these businesses which continue to turn over in his absence.
Ms. Chaskalson, can you please add one more thing? I'm interested to know how he traveled from the Northwest to the Western Cape. Did he book flights? Did he fly there? Because if he can give instructions to
The adverse inference point. I'm talking about the adverse inference in the specific instance of not participating in a voluntary medical examination. That's what I was addressing. What Chair is putting to me, I think, is something slightly different, which is like, and I've not been an acting judge yet, but when that happens, should it happen, obviously, Chair, what you're putting to me is the ordinary decision-making process that a judicial officer goes to in circumstances where you will weigh probability, credibility, admissibility, and so on. And if you draw an adverse inference at the end stage of your report writing in analyzing the evidence, that can't be objectionable. That's the ordinary rules of evidence as we understand it. So if at that stage you draw an adverse inference, for whatever reason you draw an adverse inference, I don't think in principle that there can be an objection to that exercise of inference drawing. I was addressing the adverse inference point about the prior step regarding the voluntary election. So, in direct answer to you, Chair, if I was the decision maker and it was argued in front of me that an adverse inference must be drawn, that Mr. Carrim is a naughty person, so to speak, because he didn't participate in the voluntary disclosure.
You see, that's what I'm trying to get out of the equation. There is an inference is being drawn and becomes adverse because of one saying, because of his failure to testify, we are drawing an adverse inference. That's what I'm trying to say. Let's get that out of the equation and just look at the evidence that's before the commission and then decide what to make of it, just as evidence that's before the commission. Of course, it will be a fact that certain allegations have not been answered, and one takes it no higher than that. So it's at that level that I'm engaging.
Then we're at Eden.
Not an adverse inference based on the failure to testify, in the sense that maybe he was being naughty. Why would he not testify? So I'm engaging you at the level of the reality is that here is evidence to which there is no answer, period.
But then we're at Eden, because that's what I was trying to draw the distinction on. If Chair puts it to me in that way, and that's the disaggregation that I was, with respect, motivating, you're not elevating the non-participation in the voluntary examination process to say, that's the evidence that you're naughty, I'm drawing the adverse inference. I can accept that. But if it's the second one, which is that it's unanswered allegations and therefore I'm drawing inferences because of the failure to answer, that's the ordinary laws of evidence.
To get to that, what you call an adverse inference, to get to that, I think we would have to first make findings as to Mr. Carrim's condition. Otherwise, it's just difficult, I think. I don't know what Mr. Chaskalson would say.
Agreed. And because you'd have to consider potentially credibility or the, as I was saying, credibility, probability, veracity of the version. You'd have to engage with all of that. All I was simply saying about it depends on where that comes in. If it's the first step medical examination, that's where I may have a problem. But if it's the second step, which is what Chair is putting to me, unanswered allegations and what flows from unanswered allegations, to me that's the ordinary principles of evidence. That can't be objected to. Unless, of course, there's a question of Audi or whatever
All right, you may continue, please.
Thank you, Chair. But the second point I was going to make in respect of the medical examination and less intrusive means is that, and I say this with due respect, because we're not in Uniform Rule 36 territory, there there is no comparable direct access to a witness as far as I understand it. My understanding, and you'll know, for example, in the litigation involving President Zuma and the competency of his medical certificate that he used to excuse himself from another commission, if I'm not mistaken, which went originally in front of Judge Pillay, who might have acted with Judge in the Concourt, but is from the KZN division. There, the contention was not when the commission, that commission, I don't want to call it the Zondo Commission, but you know which commission I'm referring to. When that commission had issues with the medical certificate and the medical fitness of the witness or otherwise, they had to impugn the medical certificate as the first step, and potentially the person who authored the medical certificate, because that's the evidence upon which the witness relies to say, I should be excused from giving the evidence. So why I mention that is because what our learned friends say is that because they've come up against this medical certificate as they have, they must go directly to the witness and subject him to a medical exam from someone other than the doctor of his choosing. Whereas what they could do is they could engage the medical practitioner themselves. If they wanted to, they could have, we could have, I say we in the sense of if chair gives directives to that effect. And again, I'm not committing myself to this version, I'm just theoretically testing the proposal put in front of you, is that we could have an in-camera hearing, because obviously we'd need to test the fullness of that confidential medical evidence, so it can't be for open public consumption. But then that's what we do, and the commission might choose to cross-examine the particular medical professionals. They might wish to lead the evidence of their own medical examiner, who, you know, might give an expert view of the expert view that we've tendered. We might want to cross-examine their own expert. So that what I'm saying is that I'm not immune to the Commission's concerns about concluding the evidence of Mr. Carrim, but we've played open cards with the Commission to the extent that we can, by providing all the correspondence, by providing 4 medical reports, giving all the details of all the treating doctors, and before we must leapfrog to subjecting a person to a compelled medical examination, or potentially a voluntary one like Chair says, we must think about the balancing exercise of constitutional rights. And if there is less intrusive means that can nonetheless enable the Commission to do its job, then we would argue from the perspective of proportionality and reasonableness and balance, then that's an available mechanism. May I just make my last main submission? But before I do that, Chair, I don't know if you want to...
Just to say what Chair posits.
Yes.
I think to say says sounds stronger to me. I think there's a nuance there.
Yes, no, then I withdraw every use of the word says, and I rather use the word posits. If the transcriber can edit the transcription, that's perfectly
No, they don't need to. It's part of the engagement.
Yes. No, I accept that. And I'm grateful for the clarification, Chair, because also what I'm doing is I'm trying to be helpful to you, Chair, and the commissioners by engaging the debate and giving as cogent an answer as I can, hamstrung by the fact that I can't commit my client to a version in the absence of knowing the Commission's position and without instructions. So that's the rock in the hard place. The rock on my right and the hard place on my left, perhaps, that I'm stuck between in trying to engage you, Chair. So that's as far as I'm trying to take it. My third and last main submission, if I may, Chair, is that I've heard what my learned friend said about the recommendation for prosecution. Chair already identified mens rea as the requisite element and how that would need to be investigated, and then the prosecution would flow. All we'd point out is we've also addressed this in our letter of yesterday, which I take you got probably very late last night, if not early this morning, and we did say that if that's going to be the case, that the Commission, for whatever reason, chooses to make a motivation to the Commission that a recommendation be made that our client is prosecuted, that we get an opportunity to address the Commission before an adverse decision is potentially made against him, because that's Audi Rights 101. So Chair, that's to respond to what my learned friend said regarding everything else other than the 15th of July date. On the 15th of July date, we are in your hands and we will do as directed. Thank you, Chair. I'm indebted, and I know I've taken a long time, but thank you.
Thank you, Mr. Premier. Mr. Shaskalson?
Chair, I don't want to respond now because this is a debate, if it is ever going to arise, for another day. But I do want to place on record that we don't accept many of these submissions. And in particular, the one worrying thing that we see is what the medical reports disclose is that Mr. Carrim has not been hospitalized continuously since April. He tends to get hospitalized just as his appearances before this commission are scheduled, and that is worrying. And it's particularly worrying in the context of a situation where very basic, quite aside from his appearances, there are very basic requests for some documents to be furnished, like financial statements. It doesn't take much to issue an instruction for financial statements of a company to be made available to this commission if you're not in hospital. And what we see is a simple refusal to comply with these notices, coupled with a pattern of, as an appearance date appears, suddenly Mr. Carrim needs hospitalization. Now, it may be perfectly true. It may be that by coincidence, or possibly not by coincidence, his medical condition compounded by the stress of an imminent appearance requires his hospitalization. It is, I'm not saying it's not true, but it is worrying. And what is particularly worrying is that very, very basic requests for information have been outstanding since Mr. Carrim last testified, at a time when he was certainly fit enough to testify, fit enough to travel outside of the country, and we still wait for the documents that he promised us when he gave evidence. I don't want to say any more now. I'm hoping this never becomes an issue that we need to take further.
Now for...
Late in the afternoon yesterday, we received two different whistleblower reports, both confirming that Mr. Carrim and an entourage had been seen yesterday going out for lunch at a shopping centre in the Western Cape. The two reports corroborated the same details. They seem to be independent of one another, and they've now been confirmed by eyewitnesses at that shopping centre, who we have independently contacted. So we now have it from multiple different sources that someone who seemed very much to be Mr. Carrim arrived at the shopping centre with an entourage, went into Woolworths before going off to have a late lunch at a restaurant in the shopping centre. We've subpoenaed CCTV footage from the shopping centre, and we expect to have it received, and we expect to have it thoroughly analysed by midday tomorrow. For now, we have a concern that Mr. Carrim may be taking liberties with this commission. And that concern is amplified by other whistleblower reports that we've received indicating that Mr. Carrim has been seen at social gatherings in the Northwest over his period of ostensible incapacity. So we are going to issue a subpoena later today to the hospitals at which he's been receiving treatment to establish when he was admitted and when he was discharged, since he testified at the commission. We're also going to be issuing a subpoena to his doctor, who's based in Cape Town, to establish the dates on which he has seen Mr. Carrim. And we don't expect that it will take us more than a day to obtain this information. And what we would like is for the matter of Mr. Carrim's appearance, or non-appearance, to be stood down until Friday morning, or maybe Friday lunchtime, when it can be considered on the basis of a formal postponement application, which we would ask this commission to order him to bring by 10 o'clock tomorrow. The evidence leaders will reply to that postponement application by 6 p.m. tomorrow, and it could be heard by Friday morning at 9:30. If Mr. Carrim's legal team needs more time, If we can have that postponement application by 5 p.m. tomorrow, we would undertake to respond to it by 10 on Friday, and it could be heard on Friday afternoon, not Friday morning. But what we do expect the postponement application to address is at least the following issues. The dates on which Mr. Carrim has been admitted to hospital over the last 4 months, the dates on which he's attended medical consultations over the last 4 months, his travel movements over that period, whether he's attended social engagements over that period, and whether he's played any role in the management of his businesses over that period, and if not, who's been responsible for these businesses which continue to turn over in his absence.
Ms. Jaskelson, can you please add one more thing? I'm interested to know how he traveled from the Northwest to the Western Cape. Did he book flights? Did he fly there? Because if he can give instructions to people to book flights to him, surely he can give instructions to people to give you the names of accountants. Thank you.
So that is our request, Commissioners, that the matter stand down to be decided on the basis of a formal postponement application on Friday.
Thank you, Mr. Jaskelson.